I'm Lisa Sylvester. I'm a representative from Sylvester University, and I would like to take a moment of your time to clarify issues regarding academic freedom, intellectual property, and copyright law. So the objective of copyright is, in the words of the U.S. Constitution, to promote the progress of science and useful arts. In order to achieve that objective, authors are given exclusive rights under the Copyright Act to reproduce their works, to use them for the basis of derivative works, and to disseminate them to the public or perform and display them publicly. Our institution of higher learning will interpret and apply the law of copyright so as to encourage the discovery of new knowledge in its dissemination to students, to the profession, and to the public. This mission is reflected in the 1940 Statement of Principles on Academic Freedom and Tenure, which stated that institutions of higher education are conducted for the common good and not to further the interests of either the individual teacher or the institution as a whole. The common good depends upon the free search of truth and its free exposition. So I want to talk to you a little bit about academic practice. Within the tradition of academic freedom and with the search for truth, it has been the prevailing academic practice to treat the faculty member as the copyright owner of works that are created independently and at the faculty member's own initiative for traditional academic purposes. So examples include maybe class notes and syllabi, books and articles that have been written, works of fiction or nonfiction, any kind of dramatic works, pictorial, graphic, sculptural works, maybe even choreographic works, and even sometimes educational software. Anything that can be commonly known as courseware that is developed by the professor themselves. It is the common practice that the copyright goes to the professor. Now, I want to caution you, some institutions do not operate in that manner. Some institutions, they have faculty handbooks that declare that faculty members will be regarded as having assigned their copyrights to the institution. So you need to be very careful and you need to read your handbook. According to the Copyright Act, however, explicitly it requires that a transfer of copyright or any exclusive right must be evidenced in writing and signed by the author transfer. So if an institution is trying to hold copyright law because they have a little blurb written in their handbook, that is actually unconstitutional. They cannot do that, so please pay attention to what their handbook says, and if you have any questions, bring it up or bring it to administration attention. If the faculty member is indeed the initial copyright owner, then the unilateral institution declaration cannot affect a transfer, nor are they likely to have a valid transfer with the issuance of appointment letters or even new faculty member requiring that transference. So they can't even do that as a condition of employment. If you are the copyright owner, then and the institution wants that copyright, then you have to transfer that in writing. Now, things do get a little bit tricky when we're talking about terms of works made for hire, maybe even contractual transfers, and then joint works as far as copyright is concerned. So the pertinent definition for works made for hire is it's a work prepared by an employee within the scope of his or her employment. I apologize, okay? So a typical work for hire situation, the content and the purpose of the employee was meant to prepare that specific work, and then the employer takes copyright ownership. So in the case of traditional academic works, the faculty member rather than the institution determines the subject matter, but the institution tries to claim that copyright. Another issue that comes about is contractual transfers. Okay, so in situations in which the copyright ownership is held by the faculty or the staff member, it is possible for that individual to transfer the entire copyright or maybe even a more limited license to the institution or the third party. But again, that must be done in writing according to the Copyright Act law. So, for example, work is prepared and it was sponsored research, right? So there's maybe grant funding within that sponsored research. And When that happens, when the researcher accepts that grant funding, typically they'll sign a contract by that faculty member, that research, which is saying that the part of that ownership for the copyright is going to be assigned to the institution or to the third party who assigned the grant funds for that. Another type of issue that comes up with the Copyright Act laws are joint works. So this is when you have two or more people working collaboratively on the same type of work or same idea. And when that happens, that copyright is owned by all parties who jointly contributed fairly to that work. So sometimes it's just owned by two or more faculty members. Sometimes it's owned jointly between the faculty member and the institution for where that joint work occurred. So another issue that comes up, and this comes with new instructional technologies, typically with online coursework, is that the institution will try to claim ownership of copyright because they're saying that the professor used specific delivery systems provided by the institution. So sometimes those delivery systems can constitute as a joint work. Sometimes in certain circumstances, the institution actually can legally claim ownership. So this happens when specific delivery mechanisms are used. Maybe the main faculty member who worked on the project used creative graphic elements, or they used some type of substantive coverage which contributed to that main work, but that coverage came from administrators, staffs from the institution. So you also have to be careful what constitutes as joint work and what type of delivery systems you as a faculty member use to prepare your work. So again, that university can be awarded a joint author. Another issue can arise, or another situation can arise, where the university requires that you sign or somewhat sign over copyright ownership to the institution if they have provided funding for or maybe lab supplies for what research or what you have conducted. So again, this happens in a contractual arrangement in writing. So I hope that this helped you with the understanding of copyright law. This statement will be posted, or a statement will be posted to our website, and we are still available for consult if you have any questions. And again, my name is Lisa Sylvester, and I am available for consult when requested.